So now I will introduce our host, our Senior Director of Estate Solutions, Sarah Hilliard.
Thanks very much, Carrie. Happy to be here and do this presentation for you. A little bit about me, of course, I do have a background in estate and trust planning and settlement. I'm not a lawyer, but I do have professional designations in that space. And the goal, as always, is really to offer sensitive and practical guidance and make these topics approachable for folks. So a little bit real quick about ClearEstate, so that you guys are aware why we do these sorts of presentations. ClearEstate is essentially a modern era trust office. We deal with all things estate planning and estate settlement, and we do that in a way that uses technology to help make the processes simpler, more efficient, more step-by-step, and we combine that with human subject matter expertise, of course, and guidance to actually bring families through these processes, which can be overwhelming and complex. Now, today, what we want to talk about, of course, is some pitfalls in estate planning and how to actually avoid these, as well as where to get help. We're going to actually, before we dive in, start with a quick poll of the audience. So momentarily, you should see a poll question pop up for you. And that question is, do you have a will and power of attorney documents in place? And sorry, apologies. I think it was only the first question that was supposed to pop up, but you can vote on the questions that you see in front of you, and we will take a few minutes to kind of accumulate the answers. I'll give you a second here. I'll mention also that the second question is, do you feel your plan is actually up to date? So, was it done within the last 5 years? Does it take account any situations that may have changed with your circumstances? And finally, do you think it might be worth reviewing your estate plan at this time? And if we can, we possibly will ask that again later on after we've gone through some of the case studies we have for you today. So I have the poll results here, and I do see that about 88% of you actually have your will and power of attorney documents in place. That's absolutely fantastic because, of course, you guys are actually doing better than the general population. Typically less than 50% of folks actually have a valid will in place. And in terms of your plan being up to date, a little less is about 49%. About a quarter of you were not sure, and about a quarter of you said no, it's not up to date. So that's absolutely great to know. We do find that approximately 35% of those folks who actually have done their will have it up to date. Next here, I'm actually going to dive right into some case studies. So this is what we're going to use to kind of illustrate some of these examples of pitfalls in estate settlement when the time comes, and things that can go wrong, essentially. So our first case study, which I've called A Very Generous Gift, is about Bob and Sally. Now, Bob and Sally have a charity that's very important to them, and in their will, they have a gift of $300,000 for this charity. They wanted the gift to be significant for the charity and be able to implement particular things they had in mind. And they also have 2 children, so the remainder of their estate is set to go to their 2 children. Now, Bob and Sally, after doing their estate planning, getting their will in order, later on developed advanced age diseases in their 70s. Now, Bob passed away at age 78 and Sally at age 85, which means they lived with those advanced age diseases for several years. As a result, the estate, of course, was significantly reduced by the cost of care. Many of you may be aware, depending on where you live, of course, medical care and support care can be quite expensive, especially if it's ongoing for several years. Now, the issues that actually arose after they passed away in their estate settlement were that when they did their planning, the value of their estate was approximately $1.5 million. And so the gift to the charity represented about 20% of their estate, and their children would receive 40% each. However, at their passing, because of the amount of money that they had to spend during their lifetime to make sure that their needs were taken care of, their net estate worth was now actually $500,000. And so that's after all the sort of liabilities and everything as well. Now, the result was that the charity still received their $300,000 gift, except now that actually represented 60% of the estate, and their children received only 20% each of the estate. So here the lesson really is that you need to revisit your plan regularly. You need to ensure that it actually remains consistent with your intentions, particularly as circumstances change. There can be a number of circumstances in your life that actually impact your estate plan. And in this case, of course, this was around the actual net estate value, the value that their beneficiaries would end up with at the end of the day. Bob and Sally could have really benefited from reducing the legacy gift when their expenses, they knew their expenses would increase, or even incorporating the charity as a residual beneficiary so that they would receive a percentage of the estate rather than an amount that was set in stone. Now, moving on to the next case study. Here's a case study about May, and this one's called But Can You Prove It? This is actually a relatively common situation that arises. And in this case, May has named, she has 4 children, and she's named her eldest daughter, Juliana, as both her executor and her power of attorney for property and personal care. She really trusts Juliana and feels that she'll be great at fulfilling those roles. Now, May develops dementia at the age of 75, and she passes away approximately 10 years later at the age of 85. Now, Juliana is quite a doting daughter, and she spends hundreds of hours ensuring that all of her mom's needs are taken care of. She makes sure she gets to all of her appointments. She makes sure that her expenses are covered, all her bills are getting paid on time, her tax returns are getting filed. But Juliana, unfortunately, does not keep careful records of all her activities as her mom's POA for property in particular, which is relating to her finances. Now, the issues arise after May has passed away, and Juliana's siblings have really no awareness of exactly what's gone on in terms of the finances. But when it comes time to settle the estate, Juliana's siblings see that there's actually less money in the estate than they were expecting, and they begin to question Juliana about her actions as the POA. Now, Juliana in this case had actually acted prudently, but unfortunately, she really just could not produce sufficient evidence to back that up because she had been doing it for a 10-year period, and she had not prioritized record keeping. So the result was that Juliana's siblings took her to court, costing thousands in legal fees, significant delays in the estate settlement, and fractured family relationships. And I can tell you that typically, when estates go to litigation, the end result is often that no particular party leaves feeling satisfied, unfortunately. Now, the lesson here is that really many estate conflicts can arise when siblings are perceived or siblings perceive that they are not being treated equally. Whether they are or not, perhaps, is another story. But intense feelings do rise to the surface because for siblings, it can often feel like one sibling is favored over other siblings, even if that's not the intention. Now, a fiduciary, so someone who's in a role of accountability to others, they must be able to clearly account for all of their actions. Now, May could have really benefited, and Juliana really, and everyone in the family could have benefited from considering a professional POA, a professional executor, in order to protect her and her family from conflict, because a professional would actually have the knowledge and the resources to ensure that proper records are kept. And they also tend to alleviate concerns of, neutrality, that they're truly an impartial party. So here we have a careful plan unraveled. So this story is about Dawn and Mary. Now, Dawn and Mary have two daughters, Sandy and Leah. Leah has a disability, and of course, very importantly, her circumstances are factored into their estate plan. Because there's special considerations where someone has a disability to be able to make sure that all of their needs are taken care of, not just financial, and certain access to benefits that they may receive are also protected. So they very wisely did careful planning to account for that. However, years go by, Dawn passes away, and now Mary is on her own, and she may not recall the exact reasons or the exact setup of her estate plan. And she receives some advice from her neighbor that her neighbor says, oh, make your kids as beneficiary of your life insurance policy. This will avoid probate. And, I've been told to do it and I've done it and it's the best thing ever, right? And we do see this situation occur a lot of times as well. Somebody receives advice that may be very good advice, but it's given to a specific person and it probably shouldn't be translated without scrutiny to everyone. Now, in Mary's case, she didn't really check in with any of the professionals that she had involved in her life. She didn't check with her financial advisor, or if she had an estate planner from previously, she didn't check in with them and she proceeded with making the change. Now, what ended up happening in this case is when she did that beneficiary designation update, she actually inadvertently revoked or canceled the previous careful planning that she had done. And when she passed away, Leah then received portions of her inheritance directly rather than through a testamentary trust. As a result, Leah actually lost access to those government benefits that they had originally tried to protect for her. And she also was unable to benefit from a tax-efficient QDT, meaning a qualified disability trust, which could have been ongoing for years into the future. Also, a careful structure to account for the management of assets on behalf of Leah. And now Sandy is really having a difficult time actually figuring all of this out. If there's anything she can do to correct it. She's appointed as the executor, and so she's got a lot of she's taken a crash course basically in what she needs to do with this legal, financial, and tax matters. And on top of that, because her parents are now both passed away, she's taking on additional supportive responsibilities for Leah, making sure her needs are met. So this is a lot for Sandy, of course. So in this case, it's really important to work, I think the lesson is that it's really important to work with expert professionals and to communicate your plan regularly with loved ones and continue to revisit it to refresh yourself on why it is you set it up the way you did. Now, Dawn and Mary definitely could have benefited from not just planning check-ins, but also a professional trustee to actually alleviate that significant burden from Sandy and ensure that everything is well taken care of. So here we have conflict of interests. Now, this case study is about John. John is in a blended family situation. He is on his second marriage, and in his will, he's created a spousal trust to benefit his current wife, Megan, for the rest of her life, but ultimately pass the balance to his son from his previous marriage. Now, this is a common structure that blended family situations can be helpful because it helps the testator, the person writing the will, to ensure that the assets ultimately go to their intended beneficiaries at the end of the day, while still providing for potentially a spouse. Now, in his will, John had included quite broad discretionary powers to his trustee to encroach on the capital of the trust for his wife's benefit. So that meaning that if the trustee decided, they could take funds from the trust for the benefit of his wife. And he then makes Henry, his son, the executor and the trustee of his will. Where the conflict of interest arise is the executor and trustee role is to act impartially, to be impartial and not favor any one beneficiary over others. Now, in this case, Henry is actually the trustee, yet he's also a beneficiary. He's the residual beneficiary of the trust. This is automatically a position of conflict, even though on the surface, it seems like everything might, go okay. There is actually an automatic position of conflict between the Henry as the trustee acting impartially, Henry as the beneficiary receiving the balance of the trust, and Megan, who has her own interest in the income from the trust. So now the result in this case is that Henry does not actually prioritize any income earning investments. So he does not put an emphasis on trying to actually earn income to distribute to Megan. Instead, he focuses on just preserving the capital of the trust. And he also interprets the powers that he has over the discretionary encroachment of capital or taking funds from capital. He interprets that very narrowly, and he actually requires Megan to make detailed requests as to why she might need funds, and he seldom approves of those requests, which is not in keeping with the spirit of John's intentions, although it's technically still permittable with the structure that was set up. Now, the lessons here is really that the selection of your executor and trustee and the ability of that person to actually act impartially, whether that's in practice or simply in perception, is really critical to the success of your estate plan. John's family definitely could have benefited from a professional executor and trustee to act as a neutral party in carrying out his wishes. And this would have not put, Henry and Megan into this clear position of conflict. It could have set them up for success instead. I'll also mention that a trust like this, is going to potentially be ongoing for a long period of time, which is a lot of responsibility for someone to manage for all that time as well. Okay, here we have an unintended exclusion. So here we're talking about Bill. Bill is a proud grandfather. He has 6 grandchildren from his 3 sons. Now, his will includes a per stirpes distribution. Per stirpes is a Latin term which essentially means by bloodline. So when you have a per stirpes distribution, this means that if one of your beneficiaries were to predecease you, pass away before you, then their children or issue, the next generation, would step into their place to receive the inheritance. This is actually the most common type of distribution that we see for families, is that they intend for the next generation to receive their inheritance. It's not the only way to do it, but it is quite common. Now, Jack, unfortunately, passes away prior to his dad, and so Jack's children are to receive his share that he would have been entitled to had he survived his dad. Now, what happened in this case, though, is that unfortunately, Bill's lawyer had included an outdated template out of wedlock clause. And this type of clause, which is really no longer used, certainly not in its original form, but this outdated clause was designed to avoid any sort of parties that were actually unknown to the person who passed away from kind of coming forward and claiming to potentially be a beneficiary, whether rightful or not. It was something that was used to avoid that. Basically, they wanted to ensure that only the known children of that person would inherit. However, I'm sure, as everyone's aware, in 2023, not all children, actually, I believe over half of children are actually born out of wedlock. It's really not something that can be sort of used as a blanket template clause. Now, and in this case, that's exactly what had happened. Bill's lawyer wasn't aware that Jack actually was never legally married to his children's mom. And so, but as a result, with the narrow way that the clause was constructed, Bill's grandchildren, who he had believed were going to inherit in their father's place, actually didn't, and they received nothing, and his estate was split between his surviving children. I often get a question on this one saying, well, if it's split between his surviving children, why can't they just make that right? The reality is they can, but legally they do not have to. So they may have a moral obligation, but they don't have a legal one. Now, so the lesson here is obviously that estate planning really does require a complete discovery of all the relevant circumstances, everything about you and your family members, and the contents of a will really does need to be personalized to those circumstances. Bill could have certainly benefited from proper discovery and avoiding the use of outdated clauses, and that didn't account for the makeup of modern families. Here we have the beloved family cottage. So in this case, Rashad and Kesha, they have two daughters, Janelle and Jennifer, and they are the grandparents of four children as well, of four grandchildren. They have a family cottage that they've spent tons of time at since their children were young, but of course, now that they have grandchildren, also with the whole extended family. They really want their family to continue enjoying this property, and so they leave the property and their estate equally to their two children. And their desire is that the cottage remain in the family after they pass away. This is also a common kind of situation that arises in estate planning and settlement, and there's definitely lots of potential pitfalls when it comes to dealing with family cottages, which are typically, they have monetary value, but perhaps more importantly, they have sentimental value. So when they pass away, there is actually a significant capital gain tax liability associated with their cottage property. That being because the value of the property has increased since the time that they purchased it, and because they also own the home that they regularly live in, which is treated as their principal residence. So there's no exemption available for this cottage property. That liability needs to be paid when they both pass away, even though they want to transfer the property itself to their beneficiaries. So there's a question of where is the tax liability money going to come from, right? There's no plan for this. There's also no plan for how Janelle and Jennifer are actually going to co-own the property together. So the result is that the cottage property quickly becomes a burden to Janelle and Jennifer because now they actually have less of an inheritance in cash than they had expected because of the tax liability. And of course, there's also ongoing costs of maintaining a cottage that was not previously in their budgets. And emotionally, it causes a great strain between them because they need to figure out, there's practical and logistical things around maintaining a cottage property, right? Who's actually paying the property taxes? Who's actually, opening and closing the cottage if that's necessary? Who's, taking care of it, doing all of the regular bills? And the thing we see the most conflict arise is who gets to use the cottage when, right? Are they all using it together? Are the separate families? Who gets the long weekends, basically, right? So now, in this case, they certainly could have, failing to account for the estate expenses, particularly tax liabilities, which can be significant. And these practical and logistical implications really can lead to undesired outcomes, right? In this case, there's no more family harmony. So not only is there intention of, having the cottage be enjoyed by their family ongoing into the future, like that's not possible, but also there's just a complete breakdown in the relationship between their daughters. So they really could have benefited from, considering a trust or considering different types of structures to actually consider those the expenses and the ongoing maintenance of the cottage, and perhaps even having their daughters do a co-ownership agreement so that they could truly be set up for success. Okay. Here we have the unequalized inheritance. So in this case, we're going to talk about Nicholas and Pedro, who have 2 adult children, Isabella and Louis. Now, they plan to provide significant gifts to their children upon various life events. And this is important to them because they actually want to help their kids while they are alive. And they intend, though, for those gifts, because they are significant, they intend for those gifts to be equalized in their estate, meaning that if they've given one child more than the other during their lifetime, they want that to be equalized for the other child when calculating their estate distribution. Now, in order to accomplish this, they include a hodgepodge clause in their will, which is the type of clause you would use in that situation to equalize gifts during lifetime and the distribution of the estate. By the time Nicholas and Pedro pass away, they have actually provided 2 significant gifts to Louis, once when he purchased his first home and once when he got married. Significant life events that they wanted to provide a gift for. Now, Isabella just so happened to never have purchased a home nor married. So she did not actually receive any significant gifts because these life events did not occur for her. And as a result, after Nicholas and Pedro passed away, of course, the plan was that this hodgepodge clause in the will would allow for the gifts to be equalized. However, Louis was apparently forgetful, and he claimed that he did not recall ever receiving those gifts, and no proof of those transactions could actually be produced. As a result, Isabella and Louis received their shares of the estate without any equalization, which means that Louis, when you combine gifts during lifetime and gifts in the estate, received more from his parents than Isabella did, which was not his parents' intention and did not make Isabella feel very great. So, perhaps a bit dramatic, but they never spoke to each other again as a result. Now, the lesson here is that estate planning doesn't stop upon the signing of your will, of course. All the relevant facts that are actually related to your estate plan must be carefully documented so that you can actually ensure that they can be understood and fulfilled when the time comes, right? And, unfortunately, this is a theme I always talk about, but you can't rely on beneficiaries to be honest and forthcoming. I mean, that is just, I would love to say that you can, but the reality is that the legal and the accounting side of things must be structured in such a way that, prevents the need for somebody making a moral decision about what's right and wrong. You set them up for success by having everything carefully documented. Now, they certainly could have benefited from actually having those gifts documented in writing and kept that documentation securely with their will, or wherever it needed to be so that their executor would be able to actually have it when the time comes. Okay, so we've gone through, of course, several case studies, and these were designed to basically give you a few examples. This is really like a handful of examples. There are much more examples of different things that can be overlooked or missed when planning for an estate, because it can be complicated how things actually play out, and to think those things through is very important. In general, estate planning matters because, you want to protect your loved ones. You want to help them to maintain family harmony and avoid potential for conflicts. And you also want to lessen the burden of estate settlement because it's a significant burden working through, right? Regardless of what actually is involved in terms of your assets. Like, acting as an executor takes hundreds of hours over a period of, 18 to 24 months, and is a significant amount of responsibility and even legal liability. You also want to look at minimizing expenses where possible, right? Can you reduce probate fees? Can you reduce tax liabilities? And if ultimately at the end of the day, you will have estate expenses, but do you actually have you tried to minimize them to the extent possible? And do you actually have a plan for paying the liabilities in your estate? You also want to protect your assets, of course. So you really want to safeguard your financial future and your family's financial future as well. And I think it's important to note that this also applies to, we're not just, when we talk about estate planning, power of attorneys, which is another point on here, is sometimes a kind of overlooked, but it's actually really important that you also address your power of attorneys and making sure that if you were to become incapacitated, you have a proper plan in place for that as well. That's going to continue to take care of all of your needs. And of course, you want to dictate how your wealth is ultimately distributed. Selecting the right representatives is super crucial to ensure that you actually things are going to go to plan, really, right? And that there's every estate comes with its own kind of set of challenges, and it's really important that you have the right representatives to address those. Of course, your healthcare and your last wishes, you really want to be able to outline those, lay those out clearly so that there's no guesswork to be done, especially if there's tough decisions to be made. And then, of course, you always want to customize for your needs. Your estate plan should factor in your specific circumstances and your family's specific circumstances so that you actually have the best plan possible given those circumstances and your goals, of course. So here we have, do you think it may be worth reviewing your estate plan at this time? So I'll give you a second there to answer that. Okay, so it looks like 83% of you felt that it's probably worth reviewing your estate plan. I think ultimately, the goal here is not necessarily to make you feel overwhelmed in terms of, what it is you have to do and think about. But I do think that, if you engage the right help with reviewing your estate plan, you can feel confident that your family will be set up for success when the time comes. I know it's not a fun topic. It's not fun to do. Here, I just wanted to highlight a few a few points on how intergenerational wealth transfer is actually changing. ClearEstate is, of course, a modern era trust company. We actually are a significant departure from traditional service providers. The reason that our services are resonating so much with folks is because it's a space that actually requires quite a bit of support, and right now there's not a lot of different types of options available for folks. So of course, when we talk about, the social aspect of things in 2023 and beyond, the makeup of families is different than it was 20 years ago or more, right? And those family compositions are actually becoming more complex, and there's more sort of dynamics involved to them and layers of things, and there's beneficiaries or intentions that are different, for and should account for each party's specific circumstances, right? All of that also means that modern families are actually more prone to conflict than they ever have been, right? And so when it comes to technology, there's a lot of emerging technologies and the consumer adoption of those technologies that is actually changing the way the world works, the way businesses operate, and the types of services that we can actually provide to folks. And I want to emphasize that it is human guidance that can now be enhanced through technology, which is really exactly what ClearEstate does. That it's not necessarily that humans can be replaced, because the practical application of knowledge is something that human experts are still very much needed. However, how they go about doing that can be much more efficient. On the legal side of things, in terms of legislation regarding, we saw like when, now more than ever, people are much more accustomed to virtual, meetings, virtual, this webinar, all of these things that we can actually do even in the court system that we couldn't do a few years ago because of that adoption of technology, but also that there's other changes that are causing complexity in legislation. There's always something that is changing that potentially has tax implications for folks. And so all of this needs to be looked at again. Law is typically kind of the legal, the way the courts work and legal structures are typically kind of the last to adapt as we move forward. Nevertheless, they are adapting, and as those things change and evolve, it becomes more and more important to ensure that we're looking at our estate planning, making sure everything is up to date, and making sure that these kind of buckets are factored into how we're doing our estate planning. Now, before we get into the Q&A, I just want to talk a little bit about how ClearEstate actually supports folks with estate planning. I have a slide here that talks a bit about our estate planning process. And what we actually do is a sort of, you have a dedicated estate professional. So you have a human to guide you through the entire process. And then we use our platform to collect and compile the information, of course, securely, and organize it in such a way that it's documented, but also you have a clear view of it, which is very important. And then we provide guidance and coaching about the key decisions that you have to make in your estate plan. And that helps you with us to develop a personalized estate plan. You have a clear visual distribution of your assets, and you can reflect on, all sorts of things, and including, possibly minimizing taxes, reducing probate, other potential tax efficiencies that you could employ, or different protections that you could have for your family and your beneficiaries. And those are incorporated. There's an implementation stage of actually creating the documents, incorporating your wishes, kind of optimizing your plan, getting those documents executed, and then of course securely storing everything in our vault, and making it easily accessible for you at any time, but also, for your loved ones when the time comes, and ongoing reviews to make sure that everything stays up to date and, there's sort of no stone left unturned. I do want to talk about our professional executor plan. So ClearEstate can actually alleviate that burden entirely from your family members, which means that they will not have this legal liability and the burden of the duties involved in your estate settlement. Of course, this can help alleviate lots of different issues that can arise, and also make sure your plan's set up for success. The cost of ClearEstate, we are affordable and accessible, both in terms of pricing, but also in terms of being able to meet with us virtually, being able to access your online profile. Typically, we cost about 1/3 of what traditional service providers charge. And I'll mention that in many jurisdictions, there is some type of guideline for executor compensation, because of course it's a lot of work and responsibility to take on that role. So whether it's a professional or a layperson, a family member or friend, there is entitlement to compensation. And the guideline for that is actually 5% of the fair market value of the estate assets. Now, what ClearEstate and as a professional executor, we actually charge less than what the guideline is. And if anyone has questions on that, we can talk about it in more detail, of course. But I just wanted to highlight that. You have the continuity of a professional trust office. That means that no matter what happens in terms of, if you appoint an individual and they get sick or they pass away, then you have to figure out, okay, who else can I have to act? Or, worse, if they pass away or get sick or something happens to them while they're already acting, complications can really arise there. So you have the continuity of knowing that, of course, you have the expertise and the experience in estate settlement that's at the ready to actually act and when the time comes. You also have the fact that we're independent and impartial, right? So we're not affiliated. We're not like owned by any bank, and we're impartial as a professional as well, so that can protect your family, of course. And because we use our platform to actually communicate with beneficiaries of an estate, this guarantees that they'll have transparent communications about where we're at in the process, and what information is relevant to them will be easily available to them, and their questions will be addressed, of course. This, of course, also can alleviate, make things easier if your loved ones are not actually local to you, because that can be tricky to deal with. So we can make that easier. And we can provide additional support if there's advanced planning needs, if there's a beneficiary that's a minor or has a disability or other needs, can all be incorporated in the plan. And ClearEstate with this plan could potentially be a trustee if the funds need to be held on an ongoing basis in future, and obviously ultimately alleviating a significant burden from your loved ones. So I do want to just highlight real quickly, because of course you don't have to take my word for it, but ClearEstate does commonly receive high ratings and reviews from our clients. Here I've just copied and pasted a few of them to share with you. But ultimately, I think the moral of the story here is that, our focus on client satisfaction is very high, and our use of technology makes the process easier, but also the human guidance and support is highly valued as well. Now, of course, we're going to move into Q&A, but I also want to highlight that if you guys want to know more about how ClearEstate can actually support you in your specific situation. We offer free, no obligation consultations. You can visit the link that's here on the slide. And of course, we do offer a 10% discount to all CARP members. And so that will be available to you as well. And you can ask specific questions and find out more about how ClearEstate can actually support your estate plan and your specific needs. But I think now we can move on to the Q&A. And I will note that there was lots and lots of questions, hundreds, in fact. So of course, we absolutely cannot get to them all. Excuse me, sorry, I'm losing my voice. But we will do our best to answer several now. And Carrie, if there are any live questions, of course, happy to try to address those as well. But yeah, why don't we dive in and see?
Absolutely. Let's
sorry, I think you said this earlier, Carrie, but one way or another, whatever questions were submitted, we will most definitely address them, even if not here in this session, either in a separate session that we can send to you or individually reaching out to you. Yeah, okay. Great question. And I think we pretty consistently get this question or some version of this question. And I understand why. Of course, it's something that it makes sense that folks are thinking about. And certainly there's I feel there's more and more of a desire to kind of even help adult children during your lifetime more now than ever before, probably because life is just so expensive these days. But what I will say about this is you have to remember that when you joint assets with someone else in a right of survivorship way, so that when you pass away or whichever one passes away, actually it goes to the survivor. You need to remember that you're actually giving them this right now, which can have tax complications, or I'll say tax implications, which may be fine with you, but it's something to think about. So it's as if you're disposing a part of that property if you're making someone who's not your spouse a joint owner on the property, right? And so that could trigger potentially capital gains taxation, could have other tax implications to you. So that would need to be thought about for sure. I think when it comes to capital gains taxation, it's always we talk about, okay, there's going to be capital gains taxation in your estate. So then people start asking if they should gift now. The reality is there'll be capital gains taxation at some point. The question is, when really, right? And whether it can be reduced in any way. The other issue, though, that is perhaps more significant is that because you're doing that, you're giving up control over that asset. So, or at least giving up part of the control of that asset, right? So what I mean by that is, let's say it's your home and you're making your adult child joint on your home. Well, now anything you decide to do with that home, including, financing or refinancing, lines of credit attached to the home, like renovations, repairs, going and doing, like selling it, for example, you all have to have a say in that, right? Like technically, even though in theory that might not be the plan or intention, but legally that is what it is. The other thing is that if, for example, you actually need more funds for whatever reason than you expected, like unfortunately in a situation where an advanced age disease is developed and you actually have to spend more on your budget than you expected, Will you actually need to kind of like redeem part of that joint asset in some way? And, if you do, is there going to be complications there, right? So there's risks associated with doing this. And so there's no simple yes, no answer. It's really dependent on the specific circumstances and your intentions and the risk you're willing to take. But generally speaking, I always advise to think very carefully about it, because you may be initiating some savings, like probate savings. However, you may be also be creating other issues for yourself. Great question. Great question. So, technically, you don't need a lawyer to do a will. You do need to ensure that it's properly executed and fits within the requirements of it being considered valid in your jurisdiction. Generally, that means that it has to be signed and witnessed by at least two witnesses, unless it's entirely in your own handwriting. However, I would say that, as we've seen from some of the presentation today, that estate planning is not necessarily straightforward. And so, taking a more DIY approach may not actually end up with the desired outcome that you want in your estate settlement. And certainly it may leave some questions as to, you may miss things that you don't mean to miss, essentially. Okay, great question. But actually, this is similar to the previous question about jointing. So less about the legal, joint issue, but more about, if you have funds that you want to gift to your children now that could actually create efficiencies in your estate and savings in your estate. But again, once the money is gifted, your child is under no legal obligation to use that money if you need it, right? So if you end up needing it. So I would just, again, caution, like, this needs to be reviewed carefully and really thought through to ensure that, it's the best. And actually, I just thought of something else that's important as well. When you're jointing assets, the other thing that it actually exposes you to is the joint owner's potential creditors, which there's been a number of court cases involving that, because the intention wasn't that you joint the asset with your adult child, and then that means that their creditors could conceivably access it, but that is the legal result. Yes, great question. Great question. So if you're the executor and the will has testamentary trust in it, so there's instructions in the will to hold funds for an ongoing period, that's a testamentary trust. You can appoint a specific trustee for the trusts, but if you don't, the default trustee is the executor. So the executor would have the responsibility of managing those trusts on an ongoing basis into the future. Is there a conflict? It really depends on what those trusts are actually about. If you're a beneficiary of the trust and there are other beneficiaries of the trust, then yes, potentially there is a conflict. Even if you're the sole beneficiary, but the trust was, designed with discretion over how the funds are used, there's still a conflict of interest, because, you're putting protections, but you're also in charge of whether or not to use those protections, right? So the answer is that, it really depends on the exact circumstances of what the trust is set up and who the beneficiaries are. But often there is a position of conflict involved. Fantastic question. So lawyers and other professionals can act as an executor To be honest, the more well-versed they are in what's involved in settling an estate, the less likely I find that they will be willing to take on that duty, because the liability really exists in perpetuity. Once you act as an executor, anything can come up even after you've settled the estate, and you have to jump back in to kind of do that role, right? So what I would say is, and when a lawyer does it, lawyers offices don't have trust licenses, and so it's not the law office that's appointed, it's the individual lawyer themselves, which means two things. One, you really don't have any continuity in place. Like, so if something happens to the lawyer, if they retire, or they move to another place and take on a different type of job or whatever the case may be, it doesn't leave your plan in a good place necessarily. And then the other thing is, because they're actually being appointed personally in the will, they typically take the full compensation that's as per guidelines. So for example, 5%, they'll take 5% of the value of the estate. But oftentimes they'll also hire their firm to actually do the probate application itself. Which means that you're still going to also pay additional legal fees. And this may not be the case every time, but in my experience, it's what I've seen. And so I think it's a question of thinking through carefully, like what are the advantages and disadvantages of considering a lawyer or another professional. I can tell you that if you're working with ClearEstate, we have transparent flat fee, we have a percentage, but it's fully transparent for executor plans. And on top of that, we actually included in that is preparing the probate application as well as doing all the tax filings for the estate, the final tax filings, and communicating with the beneficiaries and all those administrative details. So now, with respect to whether you should engage a family member, there's really not a right or wrong answer to this. However, I will say that, during a period of grieving, and I know this personally myself because I've been through it, even when, and obviously I have a high level of experience, but even still dealing with this when also dealing with the death of a loved one is very difficult. And so I would say, as someone who has been there, I would have liked to have maybe had a professional involved because it could have alleviated some stress and some strain on me personally. So now, that being said, there are advantages to having a family member, of course. It's leaving control or more control in the hands of your loved ones who have a personal connection to you. Something that you could consider is, why not both? Right? You don't actually need to have only a family member or only a professional. You can actually appoint a professional and a family member as co-executors. And that way you have the professional guidance and expertise that are doing all the heavy lifting, and you have a family member who's there for participating in the decision-making and can be responsible for the more personal aspects of the estate settlement. Yep, absolutely. So ClearEstate services are available in all provinces across Canada. We do also service some jurisdictions in the US as well, which can be convenient for our Canadian clients who may have real estate properties in the US. And I can share with you, we do have a slide on our pricing. So I can show you what our estate planning packages actually look like. And I know we're going over time, of course, if folks have to go, but I'll stay a minute just to talk about this slide. this is what we mean when we say, we have straightforward pricing and packages. We have a few different packages that are just based on the complexity involved, as well as, how much you actually want to do with us. And so, in our first plan, our essential plan, this is really about organizing your affairs and getting everything set up in an online profile so that it'll be easier for your loved ones when the time comes. Our plus plan, now we actually provide guidance to complete your will and power of attorney documents in addition to organizing everything. And then our complete plan will include more advanced considerations, as well as, tax considerations and implications, potentially saving strategies and things like that. And then our executor plan, where we're actually alleviating that burden from your family members, is as is displayed here, and our most recommended package is the pricing here. So you can see there's a setup fee, there's an annual fee, which includes the review of your documents for the plans where the documents are included, and updating those documents as the years go by, ongoing access to the platform, the secure digital vault. And then you could see our transparent pricing. If we're acting as the executor of your estate, when you pass away, we will charge 1% of the value of your estate assets at that time. And of course, again, there's a 10% discount for card members. Yeah, great question. Great question. So I could tell you, I think this is about I'm guessing this is about ClearEstate specifically. I can tell you that, ClearEstate is a relatively new company, so it's completely legitimate concern to wonder about how we're operating. I can tell you that, in a relatively short period of time, because there is such a need in this space for a different way of doing things, a more modern way of doing things, a more efficient way of doing things. And because we've already put quite a bit of time and energy into our platform itself to actually make the processes more efficient, we are able to automate probate filings and things like that. Because of that, it's something that's resonated with clients, investors. We have significant backing in Canada, so I think ClearEstate is here to stay. We have worked out solutions that allow us to use a trust license to be able to actually provide these services, which means that you have that regulatory backing, and trust companies, while we're utilizing trust licenses, like that gives us that additional assurance that we'll be well positioned to provide the resources, as well as expertise, and have the compliance and regulatory side of things covered as well. And I will also mention that we've already helped hundreds of families with estate planning and estate settlement, and we're actually processing more estates each month than most of some of the larger trust companies in Canada.